recognizes Senator Tom Ada on Bill number 52-32.
Thank you, Madam Speaker. I move that Bill 52-32 LS enact to repeal Section 22-421 of Chapter 22, 5 GCA relative to the transfer of autonomous agency revenues to the Autonomous Agency Collections Fund be moved to the third reading file, and I would like to speak on it.
You may proceed, Senator.
Thank you, Madam Speaker. Madam Speaker, the intent of Bill 52 is to repeal basically what we know as the pilot fee, the payment in lieu of taxes, which is being assessed to basically three autonomous agencies: the Port Authority of Guam, the Guam International Airport, and to the Guam Power Authority. Now, a little bit of background on the pilot fee. Basically, it was initially established in 1985. That was 28 years ago. And it mandated that between the airport, the seaport, and the Guam Power Authority, that each pay into the general fund an annual amount of $875,000 each. Actually, basically the way it was initially directed was that between the three agencies, they come up with a total of $3.5 million annually, and that was then going to go into what is known as the Autonomous Agency Collections Fund. But since it was enacted, I believe it was the Port Authority of Guam that made some initial payments back early in a period right after a typhoon. But subsequent to that, it was only in 2011 when collection was enforced. And so a back billing of 14 years for the amount of $12.3 million was issued from the Department of Administration, and it was given to each agency: the Port Authority of Guam, Airport, and the Guam Power Authority. The Port Authority says, "Hey, we've paid into this, and so we really think we don't owe $12.3 million." The airport said, "We can't pay for this because our bond covenants preclude us from doing that." And the Guam Power Authority, they basically questioned that there was a statute of limitation, which would then basically not allow this 14 years of back billing. And so as a result, then there was an outstanding liability of, I believe, about $2.5 million that was left hanging on GPA's doorstep. Now, the justification for the pilot, the payment in lieu of taxes that's being assessed to these three agencies, according to the law, was really threefold. One was for these agencies to compensate Guam's taxpayers for the risk that Guam's taxpayers assume in the operation of the power, water, sewer, and the air and seaport operations. And it is also as compensation to the people of Guam for services provided by the general fund, such as police and fire protection, the road systems, etc. And so those were basically the two objectives or reasons for the enactment of the payment in lieu of taxes. Now, the way the mechanics work for this payment in lieu of taxes is that the law requires that these autonomous agencies transfer funds from their operating surpluses. We know that in the case of the Guam Power Authority, they really do not have any operating surpluses as such. Generally, as we do here, they project their revenues for the year, and then they project what their operating expenses are, and normally we'll start the year off with a balanced budget. And as the year goes on, things may happen that may result possibly in more revenues than was either projected. And in reality, what happens is the Guam Power Authority actually normally has more operating needs than what they initially projected for. So if in fact there was going to be more revenues than was projected, then they would actually then go back to the board and try and get the authorization to be able to fund those other needs that originally were thought they would not have the revenues to fund. Now, again, in the case of the Guam Power Authority, they treat this pilot assessment as an operating expense, and it is significant enough that they would then go to the Public Utilities Commission to request for a rate adjustment to be able to generate the revenues. And that's what they did when they received that billing for that $2.5 million that remains to be paid. They actually went to the Public Utilities Commission and petitioned for a rate adjustment to provide a surcharge to generate those additional revenues to pay for that, plus the additional funds that will be needed to pay for that $875,000 annually. Now, the estimated impact of the pilot assessment, and again, I refer primarily to the Guam Power Authority, is that an assessment of $2.10 additional on the monthly power bills for the average residential customer will have to be assessed for a number of months. I wasn't able, it was unclear how many months this would go on to pay off that back billed amount. And then an additional surcharge of 52 cents monthly to cover the cost of the annual $875,000 assessment. So for the power customers, this pilot assessment essentially comes up to an additional $32 per year to the power bills of the average residential customer. The services that autonomous agencies are being charged for, that is the police and fire protection, highway services, one could argue that these are services that are already paid for by the taxpayers. And in more cases than not, the taxpayers and the ratepayers are one and the same. And so then one could argue that basically we're asking GPA's customers to basically pay twice for the same services, which they already paid for as taxpayers. I suggest that repealing the pilot requirement for the autonomous agencies is a way that relief can be provided to the Guam Power Authority and the Port Authority customers. Now, there were objections raised by the Department of Administration, and that was the agency that actually issued the billings to these three agencies. And basically, I think the objections can be boiled down to 2 points. One is that the director for the Department of Administration feels that the autonomous agencies have not contributed to the reduction in the deficit of this government, as evidence, and this is quoting what she says, as evidence in the inequitable pay scales as a prime example. The autonomous agencies are free to compensate their employees a much higher pay scale at the expense of the line agencies. And I would just like to note to that comment that, you know, much of the rate increases that we have experienced these past several years have actually been increases to offset the cost, the rising cost of fuel, and to service the debt that is being taken out for capital improvement projects. And secondly, many of the technical and professional employees of the Guam Power Authority were really getting paid a fraction of what their counterparts are getting locally and in the mainland. And so pay raises were necessary to improve employee retention. But for sure, the pay raises certainly were vetted and were justified. And before it was in fact implemented. The second objection that Department of Administration raised was that the autonomous agencies should exercise, and again in the director's own words, due diligence in ensuring that cost-saving measures be applied in-house. Well, this first of all presumes that there's fat in these agencies. And I know that when GPA went in, I believe it was last year, for its first base rate increase in years, PUC consultants looked at where savings could be achieved. And so, you know, it isn't as if there's just a lot of fat and they're swimming in dough and all that stuff. So I believe that with Bill 52, by repealing this pilot assessment against the Guam Power Authority and the Port Authority of Guam, and I point to Guam Power Authority primarily because whatever increases in their operating expenses occur, we feel it almost immediately in our power bills. And I believe that by repealing the pilot assessment for the autonomous agencies, relief can be provided to the customers of these two autonomous agencies. So that, Madam Speaker, is basically my opening statement on Bill 52, and I ask that my colleagues favorably consider this bill. Thank you.
On the motion, Speaker Pangilinan.
Thank you very much, Madam Speaker. Madam Speaker, I certainly understand the rationale for the move to make a change in the legislation that's being proposed in terms of the repeal of the pilot. I tend to agree that it shouldn't be that we shouldn't have pilot for the purpose of, you know, GPA receiving public services such as police and so forth. But I kind of looked at that when that was put in place as an opportunity for the people of Guam to receive and recoup some of the investments that we've made in these autonomous agencies. Most importantly, when we gave them their autonomy. As we all know, at one time, we were kind of reminiscing yesterday about the farmers market and where it was at, and somebody was saying the Paseo Loop, and I said, yeah, but how many of you remember the one in Anigua over by the GPA substation? You know, and it's ironic that that property, that was a farmers market property, was given to GPA at no cost to GPA way back when, before we even moved it over to where the Paseo Loop is today. And so I looked at this pilot not as from the payment in lieu for police service and road service, but to recoup the investments we made when we turned over the assets of the power company, basically, to the Guam Power Authority and its board of directors. And we said, here is all of the money we have that have invested in it, the power plants, the easements, the power poles, and all that. And you now have a company with an ongoing operation, you know, worth $200 million. And that was the taxpayers' money. And should we recoup some of that to help now relieve some of the taxpayer requirements for public services? And can we now recoup the investments we've made by having them pay something back? So maybe I'm speaking out of turn, and maybe what we needed to do, and this was something that, you know, during the public hearing process, I forgot to ask Mr. Horecki, who presented testimony before the PUC, was, you know, he said, we really need to just repeal this law because of the ambiguities. And I said, well, I forgot to ask, well, what ambiguities are there, and how can we correct those ambiguities so that the people of Guam can recoup some of the losses, some of the investments we've made in these autonomous agencies, and put them back into more public service, so that we're not taking them and putting them in other areas. We're taking them and reinvesting them back into public service for those taxpayers who, over the years, paid for the GPA infrastructure that was turned over to them at no cost to the authority. And then the authority went on and began operating as if they were not part of this government, you know, as if they were the Republic of GPA, you know, or the Republic of GWA. You know, where we're going to charge you $8,000 to hook up water. We're going to require you to put in a 6-inch line. We're going to confiscate that line. You're going to put $6,000 in, and then everybody else that connects to that line, we're going to charge them for what you paid for already. So if the ambiguity is existing and maybe it shouldn't be for police services, maybe we should just amend the bill and say it shouldn't be for police services. But if it should be for a recoupment of the the investments that people of Guam made, and let's correct it in that fashion. You know, I testified before the PUC on some of the GPA rate increases almost always. I mean, and I point out to them that we need to take a look at this. If in fact they're still part of this government, then we need to be in this together, you know. And of course, GPA decided that they needed to be alone in terms of compensation, that they couldn't tie themselves to the Guam, you know, to the Civil Service Commission and our merit system. They couldn't tie themselves to that because it hindered their operations and their ability to retain. And at one of the hearings, and I actually asked GPA management, I said, over the last 5 years, of those that have left GPA and gone on to greener pastures, as you say, because you're always getting poached in terms of your certified technical professions, how many have left because of money? How many have left because the reason why in their exit interview they cited, I just need more money and I'm getting a better offer? Madam Speaker, out of the like 77 who left, one cited that reason. One cited that reason under the formal exit process, that they left for more money. So when we said, oh, we had to give them certified technical professional things, and because we're losing them to, you know, San Diego Light and Power and Pacific Gas and Electric, just wasn't the case. I mean, at least for those that were left and subjected themselves to the exit interview, nobody cited that. Better working conditions, following my kid to college, you know, other areas that so forth. And so we look at that, Madam Speaker, and maybe it's, again, it's trying to fix something, you know. We look at, and we talk about the power, the salaries, Madam Speaker. And Madam Speaker, just kind of just to put things in perspective, and I really did, you know, have looked at this thing every day. I spent more time on looking at this than the legislative intent on Bill 81. Yeah. But you know, let's take a look at GPA, because we cited GPA as the example. You know, from 2007, in their executive division, they've gone from 9 employees to 18 employees, and maybe some of this is restructuring, and they may be the same people. But according to GPA financial audits, and their salaries went from $430,000 to $1.2 million in the executive division of GPA. In the finance division, you know, from 2007 to 2012, salaries went from 1.4 million to 1.9 million, and went from 24 to just 25 employees. The administration division went from 1.9 million to 2.4 million dollars, and they went from 35 to 24 employees. But salaries went from 1.5 to 2.4. And again, this is from the financial audits, and maybe there was some internal juggling, so people got moved out of finance, and so it really wasn't a reduction of 24 in that. But it is. I mean, they just reclassified. That's what the customer service went from 2.4 million to 2.9 million dollars. Employee count went from 63 to 59. You know, and so this is what happened. It really, we kind of, you know, not look at this. One of the things I had placed in the PUC regulations or enabling legislation was the authority for PUC to do some management and performance audits. Before, PUC was only looking at financial audits, and that was what they focused on. And I said, we got to take a look at, are they efficient? Because really, you know, we've been subjecting ourselves to all these rate increases, and they are making the investments. But I mean, when we look at this and the average GovGuam employee, and then power rates have increased every single year along with this, and the majority of those pay increases, I contend, and I agree with and stipulate to, have been from fuel increases, but we've also had operational things that have contributed to the cost of operations of GPA. But as they move to be more efficient, as they move to be more businesslike, they've moved away from working with people and working with our hardworking people to try and help them with regards to their needs in terms of power and so forth. So we've kind of moved from being, they've just become a little bit less compassionate. And I know people are saying, my God, there's that Democrat again, you know, wants the government to take care of everything. No, but we are in this together. And we need to work together on this thing. And sometimes these autonomous agencies want to work alone. But when they need the government of Guam, as we're going to see in legislation that's going to come before this body, that they want to be able to say, you know, we need the government to give us sovereign immunity, to waive our, you know, so that we can't be sued, but the government can if we default on our loan, or we can be sued. I mean, we tried to work with that. That's a cost. That's almost a, you know, a letter of credit or a guarantee, but it impinges upon the general government and the general fund's ability to manage its finances in terms of borrowing in order to meet the needs of the general population of Guam. And when we do that, and we give them the full faith and credit of the government of Guam guarantee, it ties us up, it frees them up, and they raise the power rates. They don't give us credit for doing that, and I think we should charge a commitment fee. You know, if that's the case, if that's the way they want to do these things. And that's why I think, you know, I understand, and I think it is correct and proper that this pilot should not be tied to police services and should not be tied to, you know, highway services. I think it should be tied to recouping the investments that have hundreds of millions of dollars that this government and the people of Guam, who paid for those through their taxes and through the rates as well, because when they were all within the government of Guam, we were subsidizing them with our taxes in terms of operations in a large sense in the early days. Recoup some of the loss, some of the investments we've made there, and take that money and then give better service to the general taxpayer. And you know, if that's how we should fix this, I'd like to look at it. But I do agree with the author of the legislation that we really shouldn't tie this recoupment of that investment and say it's because we're providing them police service and so forth. So I don't dispute that. I stipulate to that. But the concept of pilot, at least when I looked, you know, early on when we talked about this, was to recoup the investments, and you'll find it in the legislative record, you know, that was the perspective that I was coming from back then, was to recoup the investment that we made on behalf of the people of Guam in these autonomous agencies as they move forward in streamlining and managing their operations. But it's like any other investments. People who invested in that should get some return. And I still believe that in some form or fashion, whether through some more compassionate policies to our people who invested in all that, maybe that's where we need to do it. You know, maybe through a green bank that GPA can fund so that those individuals who may not be, who can avail themselves of a small loan program, a $5,000 or $10,000 loan program that they can put, the GPA can then lend to these things to put in solar, you know, to cut 10 or 15% of their power. Something like that, some kind of return on the investments that the people of Guam have made in these autonomous agencies. And you know, when Fred said there's some ambiguities, I thought maybe it was an opportunity to just change the concept and change the thinking in terms of why there should be some kind of return to the general taxpayers of Guam through a payment back to the general fund for the improvements of additional public services from the investments that we've all made in these autonomous agencies. Thank you very much, Madam Speaker.
Welcome. On the motion, Senator San Nicolas.
Thank you, Madam Speaker. I rise in full support of this bill because I believe that it is our responsibility as a body to do everything that we can to lower the cost of living to our consumers, and if this bill will help to do that, then we need to move in that direction. However, I also wanted to take this opportunity to make a call out to our autonomous agencies and ask them to revisit their perspective of their role in this government. As autonomous agencies, they're given so much freedom to operate to meet their core missions. And in more ways than one, they've done a fantastic job of doing that. But what bothers me, Madam Speaker, is I see these autonomous agencies meeting their core missions and doing a very, very good job of it, generating revenue to continue their operations and to expand, as they should. But then I also see elements of this government that are in just shambles. I visited all of our public high schools, Madam Speaker, and took pictures of restrooms falling apart, of classrooms that are an embarrassment. And I've seen firsthand the needs of our government and the financial hardships that many of our students are sick in the hospital, our elderly, our disabled. Many of these core constituencies are not getting enough resources to have a quality education, to have a quality healthcare system, to have a quality support system for the disabled or for the elderly. And all of these support systems, Madam Speaker, depend on only one source at this time, and that is taxes, fees. But the profits of our autonomous agencies are not making it into these high-need areas of our people. And that really bothers me, Madam Speaker. When I was in the private sector, I would see purchase orders coming in from autonomous agencies that, I mean, of course, they're obviously for needs, but when I compare them to the needs of our schools and the needs of our hospital and the needs of our community, they look very, very rich to me. I saw a purchase order for a boom lift so that light bulbs could be changed. And the quotes that I was getting on that boom lift were $150,000, $200,000, $250,000. And I was thinking to myself, of course, surely there's a need for this, and surely the agency can justify it. But man, how many bathrooms that could fix. How many classrooms that could fix. And so I wanted to take this opportunity to put a call out to our autonomous agencies to revisit the role that they have in this government beyond their core mission. Because the original intent of this law that we're going to be changing with this bill was to allow for any operating surpluses to come back into the government for us to meet these other needs of our people. And when I see these rich purchases for obvious needs of particular autonomous agencies, and I compare those to the suffering of our other core constituencies in this government that aren't getting enough resources, it just makes me sit back and say something is very, very wrong here. And I was particularly bothered in the hearing for this bill when I heard that one autonomous agency in particular, over the last 3 years, had 0 operating surpluses. And I sat back and I said, so they perfected the cost of operations so much that they were charging the lowest possible amount to our consumers and balancing all of that out perfectly with their operation so that they weren't charging more than they had to our people, and they weren't costing more than they had to operate. And I sat back and I said, that's just not possible. It's not possible because there's no way that you're going to perfect that kind of a system. In the private sector, when you look at private companies, they either have a profit or a loss. But to come in 0, 0, 0, what you've done is you've mastered the art of utilizing 100% of your revenues to meet 100% of your operations, to have 0 surpluses, to have to go back and pay for this pilot charge. And that bothers me. Because then what you're doing is you're just trying to make sure that you're expending everything at the end of the fiscal year to zero everything out so that you have nothing left over. And from a financial point of view, Madam Speaker, that's possible. I mean, it's obviously possible because it's been done and it's being done. But when you step back and look at it, It's unreasonable. It's unreasonable because we can look at a recent agency in my lifetime that was privatized, the Guam Telephone Authority. And when it was privatized, we didn't see rates go through the roof. We saw services increase, we saw product offerings increase, and no doubt the owners, the shareholders of that newly privatized entity are making a profit. If that entity was still in the government, would they also still be showing zero operating surpluses? So I want to make a call out to our autonomous agencies and say, look, do we need to privatize all these autonomous agencies in order for them to be financially efficient and start generating profits that will be going to shareholders? Or can you start operating in a way that's going to generate profits that will return to this government? Because our kids need the money, our sick need the money, our elderly need the money, our public safety agencies need the money. And I look at these autonomous agencies and I say, I know the money is there. So can we now come back as a true government, one government that services our people, and take this good faith autonomy that we've given to each of these agencies and fulfill your core missions, but return that good faith by operating as financially efficient as possible to get the money back into the government in the service of the people? Is that too much to ask, Madam Speaker? I don't think so. And I know that the autonomous agencies are listening. So please, review the way you're doing business and look at how it's affecting the entire community and realize that yes, you have a core mission to fulfill. And this government has allowed you to operate autonomously to fulfill that core mission, but it's not meant to be a rich and lavish assignment. It's meant to give you the authority to do what you gotta do, but operate in good faith and give back. I know you can. Do we need to implement policy to make that happen? Do we need to pass laws to make that happen? Or can we make it happen now? I think we can make it happen now. And our school children need it. Our elderly, our sick, our disabled, our community needs it. I would love for our autonomous agencies to hear this call. And instead of figuring out how to hide behind their fortresses or how to zero out their surpluses, figure out how to give back because we need it. Thank you, Madam Speaker.
You're welcome, Senator. On the motion, any other speakers? One last call. So, Senator Ada, would you like to close? You want to send it down? On the motion then to send Bill 52-32 to the third reading file without any objections or... Mr. Vice Speaker, on Bill number 56-32, you're recognized. I'm sorry, 53-32.
Thank you very much, Madam Speaker. I would like to move 53-32 to the third reading file. I would like to very short opportunity to speak.
You may proceed.
Thank you very much, Madam Speaker. Madam Speaker, I don't claim authorship of this. I may be the sponsor, but I was a proud sponsor because it was actually sent to me by a very responsible agency. It was the Guam Community College. Their legal counsel wrote this legislation, sent it to my office and asked for us to submit it on their behalf. And to their credit and to the credit of their president came down and testified at the hearing. And after that very eloquent speech by Senator Nicholas, I'm not going to attempt. I'll just read what the GCC president said because I don't think I could come close to that. And so the Guam Community College president submitted this testimony. You'll find it in the committee report. And she writes, the Guam Community College supports this legislation. About a year ago, the college updated its enabling legislation by replacing the term vocational education with career technical education to be in line with federal legislation and initiatives that recognize career and technical education. In doing so, we also have the opportunity to update other language in the legislation, specifically as it relates to the GCC Procurement Authority. GCC's goal is to work towards the enactment of legislation that clearly states that GCC is authorized procurement power in accordance with and pursuant to 5GCA. The current language in Section 33105 of Chapter 33 of Title 17 of the Guam Code Annotated appears to overreach this goal, as it instead grants this college authority to promulgate its own services and procurement regulations. We believe that the current statutory language does not meet the needs of GCC, and it is only necessary for the college to be authorized procurement power, and it is not necessary for the college to be authorized to promulgate its own rules for procurement. We believe that Bill 53-32 corrects the current legislation, which inadvertently gave GCC autonomous procurement authority. I think that very succinctly explains the reason for which they submitted this, and very succinctly expresses the reason for which I asked my colleagues to support the passage of this legislation, to do, as the retiring speaker said, to have the autonomous agencies recognize that they have been given nearly unlimited power, but they also should recognize that if necessary, that they should agree to certain things to fall back into line and assist and become part of this one government. And so I applaud the community college for having sent this to me for introduction, and their president for having submitted the letter in support of the legislation asking for our passage of this. So I ask for my colleagues' support on this. Thank you.
Welcome. On the motion, are there any speakers? So on the motion then to send 53-32 to the third reading file without any objections, so ordered. Mr. Vice Speaker, you're also again recognized for Bill 56-32.
Thank you very much, Madam Speaker. I'd like to move that Bill 56-32 is amended by the Committee on Aviation, Ground Transportation, Regulatory Concerns, and Future Generations be placed in the third reading file, and I'd ask for a short opportunity to speak.
Yes, you may proceed.
Thank you very much, Madam Speaker. First, I want to thank the chairman of the committee for having done this hearing so expeditiously, and I'd also like to thank the co-sponsor, Senator Tom Atta, for actually referring this piece of legislation to me. Being as diligent as he is, Senator Atta, I heard the call from the judiciary about the problems that they were having with GFD and GPD citations, and Senator Atta contacted the Attorney General's office to see how he could assist in addressing the problem they were having with the court throwing out or not willing to hear any of their citations and their tickets without the presence of a attorney from the Attorney General's office, because it was a criminal case. In the last session, this legislature passed a bill that made the criminal citations at GFD a civil citation, and the Attorney General also had prepared legislation as it relates to how to deal with the traffic tickets, and Senator Atta very graciously, recognizing that I was chair of GPD, asked if I would be willing to be the main sponsor on this, and I was very thankful that he asked, and so I submitted it. And the chairman of the Committee on Aviation also received testimony from the Attorney General's office and from the court in support of this piece of legislation, and they've made some additional amendments to it, and so the committee amended the bill to include the recommendations of the Attorney General to improve what they had originally sent over and was introduced as Bill 56. Madam Speaker, when I was a judge, I would much rather do 10 murder trials than I would one day down in traffic court. And it was frightening, having to deal with the testimony that was down there. And when Judge Barrett Anderson took over the traffic court, she realized that these were criminal violations and that there should be an attorney general representing the interests of the territory as opposed to a police officer, and rightfully refused to continue to hear these cases without having a prosecutor in attendance and presenting the case. And in discussions with the AG, they determined that if they made it civil violation, that it could be they could continue to handle it the way that they were doing it before, and thereby relieving the Attorney General of the responsibility of having to send over prosecutors. It may have been good training for some of their prosecutors to have their initial court appearances at traffic court, but the Attorney General's Office Prosecuting Division has a lot of other things that it really can and should be attending to. They have hundreds of cases that are still haven't gone to prosecution. And just as an example, I was told that there are currently 68 defendants in pretrial detention at DOC for criminal sexual conduct, 68. I would much rather see that these prosecutors be assigned one or two of these cases and move them forward, and rather than sitting at traffic court for all day to move these things through. And I thank Senator Tom Atta and the Attorney General's Office for coming up with this, and Judge Senator Elizabeth Barrett Anderson for recognizing that there was a way to be able to address this by making it a civil action as opposed to a criminal action. So I again ask my colleagues for their support in the passage of this piece of legislation. Thank you very much, Madam Speaker.
On the motion? Anyone like to speak? So on the motion then to send Bill 56-32 to the third reading file without any objections, so ordered.
The next bill on the agenda is Bill 57-32, an act to amend Section 53-101 relative to encroachment violations. Madam Speaker, you're recognized.
Thank you very much, Mr. Speaker. Mr. Speaker, I'd like to make a motion to place Bill 57-32 COR as amended by the Committee on Public Safety, Infrastructure, and Maritime Transportation. And I would like to just briefly discuss the bill.
Hearing no objections, so ordered.
Thank you very much again, Mr. Speaker. Mr. Speaker, Bill 57 intends to create, there were several things. One is to create a separate fund from the Territorial Highway Fund for the purposes, of course, listed in this bill. This bill recognizes that there are costs involved when DPW is required to remove vehicles or objects which obstruct the safe movement of traffic. It also recognizes that the assessment, the current assessment of $10 from violators may at times be insufficient to pay for the real cost involved in the removal of unauthorized items such as abandoned vehicles and shipping containers. And it also seeks to recover the true cost of maintaining safe and unobstructed roadways, and to ultimately deter future encroachment violations. The bill proposes and like I mentioned earlier, $10, and that's a very old assessment. But it's to increase the current fine then of $100 per day for the first offense, $500 for the second offense, and $1,000 for the third and subsequent offenses. And then, as a result of those then fines, that it would designate that those fines that are collected will be deposited into a separate fund, which is the Highway Encroachment Fund, which would then help pay for the equipment and supplies and to procure the services of licensed surveyors required to effectively enforce Guam's highway care and maintenance laws. When this bill becomes enacted, it would require that DPW then would have to work very closely with the Guam mayors within a 45-day period to inform residents and business owners regarding the increases in encroachment violation fines, ensuring that there is public awareness on this matter. So at the end of the day, Bill 57 will update fees that no longer represent a true cost involved in addressing encroachment violations. And lastly, it will further help to ensure that our roadways remain safe for motorists, motorcyclists, bicyclists, and pedestrians. So I'm hoping then, Mr. Speaker, with that brief explanation that our members would consider voting for Bill 57. Thank you very much.
Senator Ada, Senator Ada, Senator Munya Barnes, Senator Uggan.
Thank you, Mr. Speaker. I certainly rise in support of the bill. And what really prompted this particular bill is we have some subdivisions where the streets are really relatively narrow. Basically, it's just a two-lane, enough for two cars to pass. And so in a number of these subdivisions, the residents in the area basically would park a vehicle that's not operative and then just park it out there, and when they need parts from it, they would go out there. And so they're basically storing this junk car out there. And the real impact that it's having, aside from just the blight that it brings to the neighborhood, because you got all these junk cars out there, is the fact that DPW in a number of cases cannot bring their buses in through that neighborhood because it is not able to fit through with these junk cars on one side and cars parked on the other side. It just can't come in. So then what happens is DPW basically says, okay, we'll pick up your kids, but they're going to have to walk out a half a mile to where the closest bus stop is out there, because that's as far as we can bring our buses in. And so that's what the kids have to do. And I guess on a nice sunny morning, that's fine. But on a rainy morning, that's certainly, it's unfair to the kids. So with the current law being just a $10 fine, it's, gosh, I can leave it out there for forever and probably be able to afford the fine if anybody ever gets around to it. And it's probably not even worth DPW's time to go out there and enforce it. So hopefully with these increase in fines, then there's that penalty which would make people think twice about leaving their junk cars out there. Now, on the surface, of course, it seems it seems relatively easy that there's this junk car parked in front of the house, so we assume that it belongs to you, and that may not always be the case. It's kind of like, hey, it wasn't registered to me. I don't know how it got there, but that's something that we're going to have to work out. So hopefully when the mayors during their education period goes around to these people and say, whoever owns this car, please remove it now, because in a matter of 15 days, you could have accumulated a total of about $1,600 in penalties. So maybe you just, if necessary, get several strong guys together, pick it up and put it in your backyard and get it off of that street so that we can get these school buses through that neighborhood to pick up our kids. So I rise in full support of this bill, And I certainly hope that, that this goes a long ways towards solving a lot of problems that exist in some of these neighborhoods. Thank you.
Thank you very much, Senator Tom Atta. Senator Tony Atta.
Thank you, Mr. Speaker. Mr. Speaker, I'd just like to make an amendment to the bill, and that would be on page 2, line 17, where it says encroachment means any refuse, trash, or vehicles. And my amendment would just to be to place abandoned or disabled vehicles, just so that we, have some type of, I mean, if there's a vehicle that's just parked there that the owner can move and be moved, then I don't think that we should just have Public Works going out there giving a ticket and it can be remedied in 3 minutes versus a vehicle that's abandoned or disabled in that area.
On the Senator Tony amendment, any objection? Anybody wish to speak on the amendment? Seeing no objection, thank you very much. Oh, wait, Senator Limtiaco.
Sorry, Mr. Speaker. Just on the point of abandon, I mean, is there a legal definition for abandon? Is it not registered? What? So I understand the intent of the amendment. I'm just worried that is there a legal determination for abandon just because it's on the road, not being used, let's say for 6-8 months? It doesn't necessarily mean it's abandoned. I'm not sure that word is the intent that the author of the amendment intended. So.
Do you yield,
Not
Senator?
registered?
Senator Tony, do you yield?
Well, we can go with an unregistered vehicle or expired registration, expired registered vehicle.
Very good. That's a completely different amendment.
Yeah.
Oh, we'll take a short
Okay,
break.
let's take a short break.
Senator Tony Atta, you're recognized.
Thank you, Mr. Speaker, for that short recess. I'd like to make an amendment to the amendment and make it abandoned or inoperable vehicle.
Senator Tom Atta on the amendment.
Mr. Speaker, I think what we're trying to accomplish here is really to be able to free up that, that portion of the highway which, when you have cars or trash or whatever, impedes the movement of traffic on that highway. So in that example that I gave, in the subdivisions up north, a bus cannot come through because you've got cars parked on either side of the road. So probably really we should leave it as refuse, trash, vehicles, but really probably the amendment we should make is at the end of line 20 and say trash, vehicles, tower, pole, whatever that is placed in, under, or over any portion of a highway and is deemed to impede movement thereon. So I would maybe if that's acceptable, maybe I would ask for just a short recess here, and then maybe you might want to withdraw your amendment. We'll add that.
when we left on the recess, Senator Tony Ada had the floor. Senator Ada, you're recognized.
Thank you, Madam Speaker. Madam Speaker, after consulting with my colleagues here, I'm going to go ahead and withdraw my amendment.
On that motion, without any objections, motion carries. Is there anyone else wishing to speak on the bill? Senator Yamashita, and then Senator Frank Hogan.
Thank you very much, Madam Speaker. Madam Speaker, in all seriousness, on page 3, I am trying to understand the whole fine proposal and what constitutes the first offense. Is there a time duration of when the item is not removed, that a second offense is made, and then the third offense? I mean, is highway going to define these procedures, rules, and regs, or are they already defined in another code that I'm just not aware of? And then it's been raised to my attention that in the fine segment that perhaps the $1,000 for the third offense might be excessive. If it is a third offense and it's there for the third day, and then the fourth day is another 1,000, then another 1,000, then do we keep piling it up until the vehicle is actually removed? And then as well, if it's such a public endangerment, should the government just not take care of it and remove it? Or is that what this is all about, that we are going to remove it?
I'm going to pose that as an inquiry. Speaker Wampat, would you like to answer that?
Yes, Madam Speaker. DPW would have to come up with the rules and regs in terms of when then would they consider the first offense and when the second offense will actually take place. So.
Okay. I'll go ahead and yield to Senator Ada to answer the inquiry, if it's all right.
Madam Speaker, I think line 8 and 9 answers that question in that the first citation that is given, basically after 5 days from the service of the notice, and if the inspector comes back again and finds that the car is still there, then issues a second notice. And then comes back 5 days later and finds that it's still there, then that warrants then a third offense notice. So I think to the question of when does it become a second offense and a third offense, I think is, in my mind, is answered by lines 8 and 9.
Thank you. Senator Yamashita?
Thank you, Madam Speaker. Okay, I see that now. So 5 days, I left my broken vehicle there. I get a first offense. In the next 5 days, I haven't removed it, so it's $500 for a second offense. And then I leave it there for a 15-day total. Then I'll get fined $1,000 for the third offense. And the subsequent offenses, does that then mean, Madam Speaker, that for each day, so on the 16th, 17th, 18th, continuous, it'll be $1,000 for that 16th, 17th, 18th ongoing day?
Senator Yamashita, if I may, if someone can read, I have 16 GCA in front of me that may answer on sub-items C and D that will probably address your concern regarding the due diligence of Department of Revenue and Taxation based on when the car is considered abandoned and when it's left. So, Speaker.
Thank you, Madam Speaker. Maybe what would also help is that we went back to look at the legislation that actually addresses this whole topic, and it's on 5 GCA, Chapter 53, Care and Protection of Highways, and specifically the section is 53106, which is notice demanding removal. So in this here, it basically says that they can, and also 53107, the summary of the removal, that they can. Department may immediately remove from any highway any encroachment. I know that what we're doing here is we're trying, because this is also new, we want to have an awareness program. We're trying to work with the violator that's in putting even 5 days in between. But actually, if you look at the legislation, which we didn't even address, is the immediate removal. And it says here, and here are subsections. A, if it's not removed prior to the expiration of 5 days from and after the service of notice. B, obstructs or prevents the use of the highway by the public. C, consists of refuse. And D, is an advertising sign of any description. So, and it says the department may remove any encroachment on the failure of the owner to comply with the notice provided for in this chapter. And then the owner shall be liable for all expenses for such removal, and in addition thereto, there's the sum of $10, and that's what we're trying to amend. So it's a very small section of this entire chapter and the sections that addresses the abandoned vehicles.
Madam Speaker, if you may, there is also a section that has just been given to you that relates the procedures of what rev and tax can do once a vehicle is noticed, and the processes of sending registered mail to the registered owner's name, and then what happens after that. So that's in, Madam Speaker, if you can just read the title so that it could be quoted for the listening audience. 16 GCA, if I'm not mistaken.
It's 16 GCA.
Sub-item C.
Chapter 3 on Section 3606 on abandoned vehicles removal and sale. And C reads, within 5 days after an abandoned vehicle has been removed and stored, the Director of Revenue and Taxation shall send a notice by certified mail of the removal and storage to the owner or legal owner, if any, as shown in the records of the Department of Revenue and Tax. The legal owner shall have then 10 days after the mailing of the notice to reclaim such vehicle upon payment of all accrued towing and storage charges. So apparently we've got these two agencies given some authority by law in terms of how to deal with abandoned vehicle.
Thank you. Senator Yamashita, does that answer any of your inquiries?
Yes, it does greatly. Thank you very much, Madam Speaker. And I know there's the issue of excessive fines that's going to be raised by one of our colleagues. Thank you.
Senator Massey. Senator Ada, you did have a point of inquiry?
Yes, Madam Speaker, and I think what it is that is the excessiveness of the fines that are being imposed. And I think if we look at the what I got off the web was that excessive fines clause is a clause of the 8th Amendment of the U.S. Constitution, which prohibits the imposition of excessive fines. The excessive fines clause limits the government's power to extract payments, whether in cash or in kind, as punishment for an offense. The touchstone of the constitutional inquiry under the excessive fines clause is the principle of proportionality. The amount of the forfeiture must bear some relationship to the gravity of the offense that it is designed to punish. So I think that the question is, when we look at the $100, $500, and $1,000, is that being proportioned to what the offense is?
That supposes an inquiry. I'm going to ask the author of the legislation if you'd like to answer that.
Of course, that's federal law. We don't have a local law in that matter, but of course we're ruled, it always supersedes our local laws. But please remember, I mean, I can understand maybe if you want to make some changes with, the $1,000, whatever it is, but the most important thing to remember here is that this law is 43 years old. $10 to move a vehicle, there's just no way. We can't even move our vehicle with $10 that's inoperable on the highway. So that truly is a factor, and that is unreasonable then in this case, but the other side of the scale. Now, and for the most part, I realize is that what we want to do is to help the department to recoup its costs when they have to go out and hire a tow truck or maybe a lifter, whatever you call those things, to pick up the entire vehicle because you just can't drive it and put it on a flatbed and to have to remove it. I mean, just think of all the cost involved to bring in individuals in the private sector who run all these kind of business, and we're working with them as partners as well, so therefore we don't control their costs. but yet we don't want the government on the other end to be strapped also with that debt. So reasonable, it depends on whoever, the individual considers that to be reasonable. Well, this $10 is definitely unreasonable.
Senator Ada, does that answer your inquiry?
Yeah, but I think we still need to find out when does the second and third offense kick in. I mean, we can have a vehicle that is there, one inspector comes by, and that's one offense, another inspector comes by, that would be the second offense. And a third person come by, would that be the third offense? I mean,
Yeah. Yeah.
5 days.
Senator, does that answer your question based on the answer that was provided through the GCA, 5 GCA and 16 GCA?
One second, Madam Speaker.
We're going to go ahead and take a legislative recess for 1 minute. This legislature is back in session. We did leave off of Senator Tony Ada. Senator Ada? Senator Tony Ada, does that address your inquiry?
Yes, it did, Madam Speaker.
Thank you. Next we have to speak is Senator Frank Huggen.
This is Mase, Madam Speaker. Buenas and Hafade. You know, Madam Speaker, when I was looking at or listening very intently to the discussion and then also looking at some of the offenses, I was going to go right into proposing an adjustment in the offense numbers. But I need to bring myself to really the intent behind the sponsor's legislation. And that is to ensure the safety of our roads, and that if in fact there's any encroachment of any of these items, whether it's trash or refuse or vehicles, and it impedes traffic, then the intent always goes back to safety. And I'm looking at this existing law, and it says $10 for every day that an individual is fined. Guess what? It's all cumulative. $10 over 10 days is $100. $10 over 30 days is $300. Who has that kind of money to be able to continue to sustain either a vehicle, if it's a container that's encroaching on government property? You know, I was told a little earlier that, well, it's happening right now. My question then is the law being carried out? Is it being enforced so that that individual who has either a container or a vehicle encroaching on government roadways is being assessed that fine? Now, if the answer is, well, it's too minuscule, you know, exerting or assigning our personnel to go out and find someone for encroaching on government property, it's just not worth it. And it goes back again, Madam Speaker, to are we serious about carrying out the intent of the law? Because it's all cumulative. You know, when you talk about a business encroaching on Guam's roadways, and you find them $10 for the first day, and come 30 days later, they still haven't removed the vehicle, guess what? $300 is going to hurt their pocketbook. I don't know of any business out there that's going to come in and say, okay, I have $300 to expend every single month as long as I continue to utilize the public access or encroach onto the roadway. And I'm leading up to eventually proposing, Madam Speaker, perhaps a reduction in the proposed fees as it stands right now. But if you take a look at the committee report, and when the report was circulating, I believe in adjusting fees, especially after 43 years. But you know, Madam Speaker, when I saw the application of the word encroachment on Guam's roadways, I signed the committee report to report out only. And that's not because there's no love lost between the Speaker and I, but it's because our own government is committing the same infraction. You know, when the landfill was being proposed at its present site in Malolo, I believe a number of us in this hallway at that time inquired, is there a plan to upgrade or to expand or to overlay Route 4 going down to Malolo? And one of the responses at that time was, well, we need to ensure that it's all public property. Guess what? The finding was that part of that roadway, parts of the roadway leading all the way down to Malolo, is encroaching on private property. Encroaching on private property. That's why DPW is not able to utilize federal funds to either overlay, not expand. I'm just talking about overlaying with new asphalt Route 4 between the intersection of Route 4 and 17 down to Malolo, so that at least the people of the South can appreciate that road that has to be traversed by our good Speaker on a daily basis. That's why, Madam Speaker, that I voted the way I did on the committee report. I support the idea of increasing fees, especially after the timeline that it was established 43 years later. But I wanted to use this as a venue, as an avenue to remind ourselves that we also have an obligation to address public encroachment or encroachment of public facilities into private property. And I certainly hope that over the course of the next year or two, that not only will those parcels of property in which Route 4 is encroaching on into private property, that that issue is finally resolved so that at least, whether it's federal funds or Guam Highway funds, can be utilized to overlay or to expand that particular roadway. And I only use that as an example because I'm sure there are other instances island-wide that perhaps either the mayors or even DPW officials can allude to or share with us that we have to address in the long term. But Madam Speaker, I stand in support of the notion of increasing the fees. And I commend the director of DPW because part of his testimony, he said that hopefully the fines will be a deterrent for future violations. And I absolutely agree with that. It should serve as a deterrent for future violations. But you and I know, and our colleagues here in the hallway, we know and we understand that in some situations, sometimes an immediate deterrent or a fine that is meant to be a deterrent does not work as quickly as it should. So increasing the fees would be extremely appropriate in this case. But I ask the question, is the law, regardless as to what the fee is right now, is it being carried out so that in fact the existing provisions are applied? And if the answer is no, then why are we here? If the answer is yes, and they're collecting the fees, but we want it to be more of a deterrent, then the answer is yes. We should be here to entertain this. We should be here to pass this so that in fact it can serve more as a deterrent, and then perhaps some additional revenues can come into the coffers of the government of Guam. Well, Madam Speaker, I certainly, like I said, I support the idea, and I'd like to move, and it's going to be perhaps a interesting conversation, but, you know, I would think that a $50 fine for the first offense is more than appropriate. How much does it cost to get a vehicle towed if in fact it's inoperable, or get a vehicle towed if in fact it's damaged, or whatever the case may be? Anywhere from $45 to $65. Depends on the location, depends on exactly where the final destination is. How do I know this? Because I have personally experienced it. I have personally experienced it. Where in fact I have had to have my wonderful T100 Black Stallion towed away because it died out on me at the intersection of Route 8 and Route 1. Probably one of my worst experiences in my entire life, where people are driving by honking and waving, and I'm in my car, they're getting upset. But that's beside the point, Madam Speaker. I just thought I'd add that as a sideline. But I'd like to move, Madam Speaker, because if you look at the proposal is that this would be a fine assessed in addition to any costs incurred for the removal of that particular item, whether it's a vehicle or whatever the case may be, refuse or trash. So I'd like to propose that the fees that are being proposed, Madam Speaker, on line 5, line 6, and line 7 be adjusted downward.
You mean line 3?
Is it 3?
Line?
No, line 5, line 6, and line 7, unless you and I are reading off of two separate documents. I'd like to propose a $50 fine for the first offense. And keep in mind, please, Madam Speaker, this is cumulative. $50 for a second day out there impeding traffic, guess what?
Senator,
It's $100.
what page are you on right now?
On page 3. I apologize, I didn't highlight the page number. On page 3, line 5, I would like to propose that that fee for the first offense be $50. Line 6, I would propose that the second offense be $300. And line 7, $50, $150, and line 7, that that particular fee be $300 for the third offense.
That
So,
would be
Madam
on-
Speaker, that would be my amendment. If you need me to place it, provide it to all of our colleagues in black and white, then
No,
I
I
would be
just
more
want to
than
make
willing to.
sure that we know that the intent also notes on page 2, it also notes for the offenses on on lines 3, 4, and 5. So, on the intent, we'll have a technical change. So, right now, the change, ladies and
you,
gentlemen,
Madam
is on
Speaker.
page 3, line 5. The first offense is from $100 to 50. Am I saying that right, Senator Ogden?
That's correct. And on line 6, $500 to change to $150. And on line 7, $1,000 to $300. Understanding two components, Madam Speaker, and that is the owner shall be liable for all expenses of such removal. That's one aspect. And then in conjunction with this, it's cumulative in terms of the number of days that that item is impeding traffic or encroaching on a public roadway.
Thank you, Senator Ogden.
Thank you, Madam Speaker.
Are there anyone wishing to speak on the Senator Ogden amendment, which changes lines 5, 6, and 7 on page 3? The first dollar amount to be $50, the second dollar amount to be $150, and the third on line 7, which was $1,000 down to $300. Do we have anyone wishing to speak? Speaker Wanpat, you're recognized.
Thank you very much, Madam Speaker. I appreciate, of course, the discussion, and I understand, of course, that, and I'm glad that the mover of the amendment agrees that that the fines need to go up. We're talking about 43 years ago, and the $10 is surely not a deterrent. But if you read on further, it does say that we want to update, of course, the fines to make it reflect the current conditions. Now, granted, they had towed his black stallion for maybe $50, but $50 is just not going to cut it when you're going to have to move a container, and or a larger vehicle, or even something smaller than that, and something that's especially totally inoperable, maybe no wheels to remove, so you're not going to call a tow truck. You're going to get another vehicle or equipment to come in again to lift that entire vehicle or object or whatever it is that needs to be removed. And that is surely not recouping the cost. So, I mean, in several discussions that we've had with our members, and maybe that's something that I'm willing to discuss, and I know we're getting very close to taking a break, but maybe just for some thought, not necessarily to dispose of this amendment, but to discuss it further, but something maybe that we can think about in a discussion I've had with some of our colleagues and even with legal counsel, looking at the current legislation, that so that there won't be any confusion here. But more importantly is, I think what's the most important thing is the initial amount that was being charged, and maybe taking that same idea of the wisdom of the legislature 40-some years ago when they wanted to charge $10 a day, that there is that violation, and that maybe the author might be willing, and and I like to just throw this idea out, but not necessarily making any kind of amendment. And for consideration is that just do the exact same thing that they did 43 years ago, where it's $10 a day, no matter what the amount is, that maybe it could be $100 every day, no matter what the number of days are, and not even go up to the 150 or even to, I don't know what the third one was, 300.
300.
So, I mean, maybe those can even be removed and just stay with the same language that the way it was written 43 years ago, and just change the dollar amount. So that's just my thoughts, and I like to work with the author. I also understand, too, that we just got word that I like to even discuss with Senator Tony Ada initially when he was talking about the first amendments that he offered, that there might be some agreement maybe just to actually remove the 3 only because they are codified elsewhere. So So
Speaker
maybe-
Wampat, we'll go ahead and consider that, but before we take a break, I'm going to go ahead and address Senator McCready for his thoughts on the amendment also.
Thank you, Madam Speaker. You know, I know we're going on recess real quick here, and I don't want to take too long of the time, but I would like to find out if during that recess and when we come back at 2 o'clock, if we can have tangible data on just what it costs to tow a truck, what it costs to tow a car, and what it costs to tow a 20 or 40-foot container. That way, you know, when
Plus
we vote,
storage.
yes, plus storage. When we consider this bill, we know exactly what the costs are.
I'll go ahead, we're going to go ahead and take a recess right now, and we will come back at, you have a point of
Just
information?
a point of information, Madam Speaker. I mean,
We,
our good colleague is I think he's reaching out and he's being considerate in terms of how much it costs for these items, but it should not matter to us. Because the cost will be incurred by the individual that has the vehicle or the obstruction in the roadway. So really, the cost factor should not be our consideration. It's either we have a fee, we have a fine, it serves as a deterrent that all these items that are going to be identified. And like I said, I mean, I pre-qualified my statement, Madam Speaker, by saying I think it's excellent that he wants all that information, but we'll, looking at it from that end,
yeah.
accomplish
Senator Uggan,
our
I will
objective
note
here.
that based on the existing legislation as written today, the owner shall be liable for all expenses of such removal, and in addition to then the designated amount. So right now, based on the request of the author of the legislation, we're going to go ahead and take a recess till 2 o'clock in the afternoon. Thank you.